I have watched authority migrate before, not through legislation, not through public debate, through the slow reinterpretation of what a right actually means when you try to exercise it. On June 23, 2022, the Supreme Court issued a 6-3 decision in New York State Rifle and Pistol Association versus Bruin. Most people heard it described as a gun rights case, a Second Amendment victory, a blow to restrictive states. But those descriptions miss what actually changed that morning. The court did not simply rule on permits. It dismantled a century-old framework that had allowed state governments to decide who deserved constitutional protection and who did not. For 91 years, New York operated under a licensing system that required citizens to demonstrate proper cause before receiving a permit to carry a concealed firearm in public. Proper cause was never defined in statute. It was determined by licensing officers, case by case, application by application, based on criteria that shifted with administrations, with political climates, with the discretion of whoever reviewed your paperwork. You could be a business owner carrying receipts through dangerous neighborhoods at midnight. You could be a victim of documented threats. You could have a restraining order against someone who promised violence. None of that guaranteed approval. The decision belonged to officials who answered to no standard except their own judgment. 6 other states operated under identical systems. California, Hawaii, Maryland, Massachusetts, New Jersey, and the District of Columbia all maintained what legal scholars called may-issue regimes. The language is precise: may issue, not shall issue. The state may grant you permission to exercise a constitutional right, or it may not. The discretion was absolute. By 2022, these 7 jurisdictions represented approximately 83 million residents living under frameworks where Second Amendment protections existed in theory, but required government approval in practice. The Bruin decision did not affect those 83 million people equally. It affected them universally. Within 72 hours of the ruling, licensing offices in Manhattan, Los Angeles, Honolulu, Baltimore, Boston, Newark, and Washington, D.C. began receiving guidance from state attorneys general on how to rewrite denial standards that had been in place since the Coolidge administration. The majority opinion was written by Justice Clarence Thomas. He was joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett. Their reasoning was surgical. The Second Amendment codifies a pre-existing right to bear arms for self-defense. When the government regulates that right, it must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. Thomas examined licensing laws from the founding era, from the Reconstruction period, from the late 19th century. He found no historical analog to proper cause requirements, no precedent for requiring citizens to convince government officials that they deserved protection before exercising a constitutional right. The court established a new test. When a modern firearm regulation is challenged, the government must identify a well-established and representative historical analog, not a perfect match, not an identical statute, but evidence that the type of restriction being imposed is consistent with how the founding generation understood the limits of the right to keep and bear arms. Proper cause requirements had no such analog. They were inventions of the early 20th century, created during an era of progressive reforms that sought to manage urban populations through administrative discretion. Justice Breyer wrote the dissent. He was joined by Justices Sotomayor and Kagan. They warned that the majority was imposing a rigid historical test that ignored modern realities, that firearms technology had evolved, that urban density had increased, that public safety concerns in 2022 bore no resemblance to the threats faced in 1791. They cited statistical studies on gun violence. They referenced mass shooting data. They argued that states needed flexibility to address dangers the founders could not have imagined. The majority addressed those concerns directly. The constitutional right to bear arms does not depend on whether a judge agrees that exercising it is a good idea. It does not fluctuate based on crime statistics or political preferences. If the right is subject to government permission based on whether officials believe you have demonstrated sufficient need, then it is not a right at all. It is a privilege, revocable at will, distributed according to bureaucratic discretion. Within 30 days of the Bruin decision, 6 of the 7 may-issue jurisdictions had converted to shall-issue systems, where any applicant who meets objective criteria receives a permit automatically. New York moved first. On July 1, 2022, the state legislature passed the Concealed Carry Improvement Act, replacing proper cause with a requirement to demonstrate good moral character. The language shifted, but the framework remained discretionary. Licensing officers could still deny applications based on subjective determinations. Within 90 days, that statute was challenged in federal court. Within 6 months, a district judge issued a preliminary injunction blocking enforcement of several provisions. California followed with Assembly Bill 2571, which redefined sensitive places so broadly that concealed carry became effectively prohibited in most public spaces. The law banned firearms in parks, public transit, government buildings, hospitals, churches, schools, stadiums, bars, restaurants serving alcohol, and any private property where the owner had not posted explicit permission. Legal challenges were filed within hours of the governor signing the legislation. As of early 2025, those cases remain in litigation, moving through the Ninth Circuit with no resolution in sight. Hawaii attempted a different approach. The state maintained its licensing system, but added a requirement that applicants complete 16 hours of firearms training, submit to psychological evaluations, and provide written statements from 3 references attesting to their character. The cost of compliance exceeded $800. The wait time for appointments stretched to 14 months. Civil rights organizations argued that Hawaii had simply replaced one discretionary barrier with another. The state defended the requirements as objective standards that applied equally to all applicants. According to data compiled by the Crime Prevention Research Center, permit applications in the 7 affected jurisdictions increased by approximately 412% in the 12 months following Bruin. New York alone processed over 300,000 applications between July 2022 and June 2023, compared to 71,000 in the previous 12-month period. Approval rates varied wildly by county. In upstate rural counties, approval rates exceeded 92%. In New York City, approval rates hovered near 18% during the same period. The National Rifle Association reported that their legal defense fund received over 19,000 requests for assistance from applicants who believed their permits were wrongfully denied under the new systems. Not all of those requests were meritorious, but the volume indicates how many people understood that discretionary licensing had not actually ended. It had simply adopted new language. Police departments faced immediate operational challenges. Training protocols needed revision. Officers who had spent entire careers under may-issue frameworks suddenly needed guidance on how to interact with legally armed civilians. Departments in major cities convened emergency sessions with legal counsel to review use-of-force policies, stop and frisk procedures, and protocols for detaining individuals during investigations. The question was no longer whether someone had a permit. The question was whether officers could assume that armed individuals in public were committing crimes simply by being armed. The New York Police Department issued interim guidance in August 2022, instructing officers that the presence of a concealed firearm, even if legally carried, could constitute reasonable suspicion for further investigation if combined with other articulable facts. Civil liberties attorneys immediately flagged the language as a constitutional violation. The guidance was revised twice in 6 months, but the larger shift was already occurring. The debate had moved from whether you could carry to where you could carry, and that question exposed the second phase of legal conflict that Bruin had set in motion. Every state that converted to shall issue simultaneously expanded its list of sensitive places where firearms remained prohibited. The logic was straightforward. If the state could no longer screen applicants based on need, it would control access based on location. New York's sensitive places law banned concealed carry in Times Square, not because of any specific threat assessment, not because of documented incidents, because it was a place where people gather. California prohibited firearms in any location where a special event permit had been issued, a category so broad it included farmers markets and street fairs. New Jersey banned concealed carry in any park, beach, or recreational facility owned or operated by the state, which encompassed hundreds of square miles of public land. The legal challenges came fast. Plaintiffs argued that if carry bans could be justified simply by declaring a location sensitive, then the Second Amendment could be nullified through geographic restrictions. Courts responded inconsistently. The Second Circuit upheld most of New York's sensitive places law. The Ninth Circuit struck down portions of California's. The Third Circuit allowed New Jersey's park ban to remain in effect pending further review. As of February 2025, there is no uniform standard for what constitutes a sensitive place, and permit holders crossing state lines face a patchwork of restrictions that change based on jurisdiction. The financial cost to states has been substantial. New York allocated $14 million in emergency funding to hire additional licensing staff and upgrade background check systems. California budgeted $11 million for legal defense as lawsuits accumulated. Maryland spent $6 million restructuring its state police firearms division to handle the surge in applications. These figures do not include ongoing litigation costs, which several state attorneys general have estimated will exceed $50 million collectively over the next 5 years. Compliance costs for permit holders have also increased. Training requirements now range from 4 hours in some states to 16 in others. Fees vary from $50 to over $400. Fingerprinting, background checks, and notarization add additional expenses. According to surveys conducted by gun rights organizations, the average cost of obtaining a concealed carry permit in former may-issue states now exceeds $370, not including the cost of the firearm itself. This creates a barrier that operates through economics rather than discretion. The state no longer denies your application because you have not proven need. It simply makes the process expensive enough that many people cannot afford to complete it. The constitutional question remains unresolved. Does a fee structure that prices out low-income applicants violate the Second Amendment? Several cases raising that issue are currently pending in federal court. The Bruin decision also triggered secondary consequences in states that were already shall issue. Texas, Florida, Arizona, and Georgia all had objective permitting systems before the ruling. But after Bruin, legislatures in those states passed laws eliminating permit requirements entirely for concealed carry. The logic was consistent. If the Second Amendment protects the right to bear arms, and if discretionary licensing violates that right, then any licensing requirement is constitutionally suspect. As of 2025, 27 states have permitless carry laws, often called constitutional carry. This has created a national landscape where firearm regulations vary so dramatically by state that interstate travel requires careful legal research. A permit holder from Pennsylvania can carry in Ohio and Indiana, but not in New York or New Jersey. A resident of Vermont, which has never required permits, can carry in Arizona but faces arrest in Massachusetts. Reciprocity agreements exist, but they are inconsistent and subject to change based on political administrations. The enforcement burden has fallen on police officers, who must now determine, during street encounters, whether an armed individual is legally carrying based on their state of residence, reciprocity agreements, and compliance with sensitive places restrictions. The complexity is considerable. Training bulletins in major departments now run over 40 pages just covering concealed carry law. Officers report that the legal landscape shifts faster than training can keep pace. What happened after Bruin was not a simple expansion of gun rights. It was a structural reconfiguration of how states regulate arms, how courts evaluate those regulations, and how millions of Americans navigate a constitutional right that exists on paper but remains constrained by geography, economics, and bureaucratic process. The decision removed one barrier and revealed a dozen others, each designed to achieve through indirect means what could no longer be accomplished through direct denial. I have seen this pattern before. Authority does not surrender, it relocates. The fight over proper cause is over. The fight over sensitive places, over training requirements, over fees and waiting periods, over what reasonable regulation actually means. That fight is accelerating. Bruin did not end the conflict, it changed the terrain. And on that new terrain, the question is no longer whether you have a right. The question is whether you can afford to exercise it, and where the government will allow you to go once you do.